We know the causes of delay in the courts, and we have attributed the causes of delay and to poor investigation, poor pretrial management of cases, and poor articulation of the evidence in court. Now, you will not expect an accused person to come to court and simply surrender his neck and ask to be convicted. Of course, even the interest of the state at times, when it tries individuals, is suspect, because there are political motivations behind it. At times, they don't even want to go on with the case. They are content with running the person as if he's guilty in the social media and saying that, and going to court, find one reason or the other that they will not go on. The last presidential committee on anti-corruption, I told them that I have never seen any one of them in court in any of the high-profile cases. So on what moral platform do they get up to say the senior lawyers are delaying cases, when I have never seen any of them in court before? And they couldn't give any reasonable answer as to why they were not, because they don't know. So the long and short of it is that those who come from the side of the defense are entitled as Nigerians to be on the committee. It's not anybody's father's birthright. We are entitled as of right because we know the reasons why there are delays in the system. And I can tell you, apart from what I have laid down, is that we seem to imagine in this country that when an accused person is taken to court today, that the case against him starts. No. In England, in the US, in all these modern democracies that have criminal justice systems, a case does not come to trial until well over a year or a year and a half. There are pre-trial steps that are taken, discoveries, documents are exchanged, issues are trashed out preliminary, and you will now isolate the case to the main issues. It takes at times a year or two. There is also the question of scheduling. Never mind you, there are cases that have been there for the past 10 years. And it is very immoral for a case to come this year and want to overtake those cases. So you need to schedule them. If people don't know that these things take a long time to deal with, the recipe for the failure of a case is let it come to court today, and you want it to go on today. That case will fail. But you have to have a period of pre-trial so that even a year's time it comes up for hearing. And remember the O.J. Simpson case and all those cases. They gave 2 weeks, 3 weeks, a month. Day to day, that case continues, and it is covered marvelously by the press, step by step. People are able to make up their mind on the evidence. So when these people come to say because defense counsel, senior counsel are defending they shouldn't be there, they want to rob us of our birthright as Nigerians. We have every right to be on the committee. We owe nobody any apology. The CJN that appointed us knew that we have something useful to contribute to it.
Away from the Salami Committee, let's bring you a recap of some of the top trending stories from the court.
Suspected kidnap kingpin Chukwudumeme Onwuamadike, popularly known as Evans, has pleaded not guilty to a 2-count amended charge of conspiracy and kidnapping. This is in sharp contrast to his earlier plea at his arraignment on the 30th of August, when he pleaded guilty to the kidnap of one Daudu Donatus. His not guilty plea was recorded during a rearrangement on Thursday before Justice Akim Oshodi of the Lagos High Court sitting in Ikeja. The rearrangement became necessary after the Lagos state government amended the charges against him and 5 other defendants. The 6 defendants allegedly conspired between February and April 2017 to kidnap their victim in the Ilupeju area of Lagos. Armed with guns and other weapons, they allegedly captured and detained and collected a ransom of 223,000 euros from the victim. Following their no guilty pleas, the court has fixed November the 3rd for their trial. Still on Evans, the suspected kidnap kingpin has insisted on the enforcement of his fundamental human rights despite his arraignment. At the Federal High Court sitting in Lagos, his counsel, Olukoya Ogungbeje, insisted that the police illegally detained his client and the court should award him 300 million naira as compensation for the alleged illegal detention. The Nigeria Police Force, in an application filed pursuant to Section 36 of the 1999 Constitution and argued before the court, contains that the court could not proceed to deliver judgment on the issue without hearing from them. The police distanced itself from the oral submissions of one lawyer, Henry Obiazi, who they claimed acted without authorization when he represented them in a previous court proceeding on the issue. They maintained that they only became aware of the matter when it was fixed for judgment and urged the court to allow them put in their defense before proceeding to judgment. Evans' counsel has, however, pleaded with the judge to go ahead and not allow the police to arrest the judgment. Justice Anker has ruled that he would have to wait for a fiat of the chief judge of the court, which would allow him return to Lagos from his new posting in Yola to decide the case. Still in Lagos, another judge of the Federal High Court, Justice Ibrahim Buba, on Monday, October the 16th, ruled that the Economic and Financial Crimes Commission, EFCC, has established a prima facie case against Mr. Patrick Akpobolokemi, a former Director General of the Nigeria Maritime Administration and Safety Agency, NIMASA. Justice Buba held that the former DG and 5 other persons standing trial with him have a case to answer. The court overruled their no-case submission on charges of conspiracy and diversion of 2.6 billion naira for lack of merit and ordered the defendants to open their defense. And we round off in Abuja, the Federal Capital Territory, with the report that the federal government on Thursday, the 19th of October, arraigned the senator representing Bauchi Central Senatorial District, Issa Misal, for allegedly making injurious statements considered to be false against the Inspector General of Police, Mr. Ibrahim Idris. He was arraigned before the High Court of the Federal Capital Territory in Maitama, Abuja, where he pleaded not guilty to the 5 counts made against him. The trial judge, Justice Ishak Bello, who is the chief judge of the FCT High Court, granted him bail in the sum of 5 million naira with 2 sureties in the like sum. The judge fixed November the 28th and 29th for trial.